All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Welcome to episode 17. So today I want to talk about something that's been driving me crazy. And I know I missed out on a lot of this over the last couple of weeks, so I'm a little late to the party, but I definitely want to put my legal footprint, my legal analysis on this issue. And I want to talk about NFTs, digital tokens, and other such things that are floating around in the community that everyone's clamoring that Adam Aaron should do. He should do this, he should do that. Well, there's a bunch of things. The NFTs are great, but that has nothing to do with the actual stock. But issuing a digital dividend token or any type of digital asset, to try to circumvent some type of, inability to issue a dividend, which AMC cannot do, anything like that. Anybody who's out there right now on Twitter and is making affirmative statements that digital tokens or digital dividends or anything like that is quote unquote legal, I'm just going to come out right and say it. They're full of shit. You know what? There's no legal precedent at all to support that assertion. That is a complete statement of conjecture. That might be their opinion, but you really can't state whether or not something is legal or not as an opinion. You can't be half pregnant. It either is legal or it's not legal. And right now, there's really no law that shows that it is legal. So if there's no law that shows that it is legal, you have to work under the assumption that it's not, because you don't want to be the test case for the courts. And that's really the reason why Adam Aaron can't do what everyone is clamoring for him to do. Everyone's under this assumption that they're allowed to do this. And everyone keeps saying that they're allowed to do it because of Overstock, with the Overstock case. Hey guys, remember the Overstock case? Overstock did it. They had no problems. There's precedent to support it. But that's not true. That is not true. Overstock, first of all, Overstock, it wasn't easy for Overstock. They did it. They did something, right? They issued a digital dividend token. And, it did cause their stock to squeeze, but it wasn't without any repercussions. There was a lawsuit filed against them. And, lawsuits are very expensive and very costly. And they got lucky because I read the decision and I'm going to talk about it. But the key word that everyone keeps throwing around is precedent. And that is not true, right? The case that was brought against Overstock, all right, guys, here it is right here. This was filed in the District Court of Utah back in 2019, right? Mangrove filed this. Mangrove is a short seller. They filed it against Overstock. And they basically said that, they did this on purpose. They filed this digital dividend on purpose with the intent to trigger a short squeeze to, cause pain on the short sellers. And now, what they did was what Mangrove did was they filed a lawsuit, right, against Overstock, and they said that they committed market manipulation and fraud, right? Market manipulation and fraud are very, very difficult things to establish. Now, remember, Mangrove is the one who moved against them, and then Overstock made what's called, you guys know this from the cases that are currently pending in Florida. They filed a motion to dismiss, pre-answer motion to dismiss, and the court granted the motion to dismiss. Now, remember, that does not mean they won anything. It just means that Overstock didn't lose, right? The case did not set forth in any way, shape, or form that digital dividends are permissible under the law. They did not set forth that the issuance of an NFT is admissible under the law as a dividend. They never stated whether or not, most importantly, a digital asset token or a digital NFT should be identified as a security or not. These are all still very pressing and very real questions that if companies just start randomly and willy-nilly issuing these tokens without any legal precedent whatsoever, what do you think is going to happen to them? They're going to get sued. And then if they lose these cases, not necessarily from a fraud or manipulation perspective, but just from an SEC perspective, if it's determined that these are securities, guess what? They're going to get slammed with major fines. So you guys, everyone's out there, touting this decision. It's not, and on top of it, not only is the Overstock decision not establish anything, but the Overstock decision is not over yet. the Mangrove just recently filed an appeal on the motion on their loss, on the motion to dismiss. So the case still hasn't even been fully resolved. It's going up to the appellate courts, and for all we know, the appellate courts can actually reverse the decision of the judge. But the interesting thing was, I read this entire decision. It's a very long decision, 32 pages long. The judge goes into why he believes remember, in a motion to dismiss, all they say is whether or not you set forth enough information in your complaint to establish whether or not it's potentially provable to establish fraud or manipulation. The interesting thing about what this judge wrote in the decision was that she said that when you read the decision in its totality, and I don't know if anyone has, but if you're going to go out there and you're going to start making comments about how Overstock is precedent and it's not, you should at least read the decision, because if you read the decision, you will get the feeling and realize that they came pretty close in losing that motion to dismiss and having this case go forward. So that's why, if you think about it, if they came close under this fact pattern, and this, remember, every situation is fact specific. If they came close, right, under the Overstock fact pattern, one can surmise that they would be able to cross that hurdle in the AMC case. Because if you think about it, AMC is so much out there, right, out in the open, and so much so under the radar, and so being looked at through like a magnifying glass. You know, when Overstock did this, it wasn't as outright, right? It wasn't as overt. But the things that are said on the internet and the statements that are made, Adam Aaron is 100% right. There is so much danger in filing this type of and in issuing this type of security token or digital token for so many reasons, let alone manipulation aspect, but even just the idea that the SEC still has not determined whether or not these types of things should be identified as a security. Now, NFTs, you know, there's a test that they have to apply to determine. It's called the Howey test, right? That's how you determine whether or not something is a security or not. And it's a 1946 Supreme Court decision that basically says any contract, scheme, or transaction is a security if there is an quote unquote an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. So that's the Howey test. That's what they would use. That's what the courts would use. Not the SEC, the courts. That's what the courts would use to determine whether or not something is a security or not. So the question would be, is it a security? And there is no decision yet as to that. But again, would it be, listen, you got to weigh things, right? You say to yourself, all right, if we issued this digital token, hypothetically, and then it's determined that it is a security, we're going to get our asses handed to us. And then on the other side is, well, if we issue the security, maybe something will happen and maybe we might win, but we're going to be stuck in litigation for a bunch of years no matter what. And the end result might be really, really bad for us as a company. When you look at fiduciary duty, and everyone keeps throwing that word around, and I'm going to do a separate video on that, because fiduciary duty isn't what you think it means in terms of what Adam Aaron has to or doesn't have to do in terms of listening to investors, but they have to look at the long-term prospects, not the short-term prospects. So from a long-term prospect perspective, Adam Aaron is 100% right about what he's doing here and refusing to do that token idea, because no matter the statements that are being made that it's not illegal, nobody knows that. That is complete horseshit. So I thought it was important to talk about that because from a legal analysis perspective, the two things that you should take away from this video are, number one, Overstock did not establish any precedent whatsoever. It was just a motion to dismiss. It never got to the merits of the case. So there is no precedent. Stop saying that. And number two, anyone who's saying that a digital token or a digital dividend or anything like that is quote unquote legal, that's also made up, because there's no precedent for that whatsoever. That is an opinion, but that is not a fact. So it should not be used as a fact, even though, and it sounds like it's being used as one, quite frankly, very often on Twitter. So anyway, that's a video for today, guys. Hope you enjoyed it. I know I'm sort of like the harbinger of bad news. I don't have anything like positive to say lately, but I'm confident that the Robinhood motion to dismiss is probably going to get denied. I'm hoping, and I have a good feeling about that one. But But this is important. Again, I'm not here for cloud likes, money or anything, or I don't really care. I just want to tell you guys the facts. I mean, from a legal analytical standpoint, Overstock's not precedent, and digital tokens are very risky, and there's nothing to support this assertion that I keep seeing on Twitter that there's some legality to them. Absolutely false. Anyway, guys, have a great day, and until next time, the Lawyer of the Apes is adjourned.